Good morning. Welcome to Kuits for this morning's presentation, a lightning briefing entitled Furlough, Did You Get It Right? For those of you who don't know us, Kuits is a commercial law firm based out of Manchester, but with national reach, handling all aspects of commercial and business law. I'm Robert Levy, I should say, the executive partner of the firm. When the coronavirus job retention scheme was introduced in March 2020, it rapidly became known as furlough, a word most of us had probably never heard before, unless we paid attention to the niceties of US financial stimulus packages or were fans of the 1950s American sitcom Bilko. It comes from the Dutch word verlof, meaning leave of absence, and like many other of the coronavirus support packages, indeed many other grants, tax reliefs, or anything that puts state money into the hands of taxpayers, the government tends to spend just a few weeks passing legislation and issuing guidance before pushing money out of the door, followed by many years of trying to get it back from people who either innocently, carelessly, or deliberately obtained it incorrectly. Having paid out over £60 billion on furlough, Her Majesty's Revenue and Customs, the Serious Fraud Office, and the police are now tasked with getting back money that was claimed improperly. From the organised crime groups, or for those of you who are fans of Line of Duty, the OCGs, who have been setting up phony businesses or selling lists of stolen identity fake employees to legitimate businesses, and to legitimate businesses that just played a bit fast and loose with the rules, to businesses that just plain got it wrong entirely innocently. One of these authorities is coming soon to a theatre near you. You'll hear shortly that the Chancellor has committed £100 million to new funding for an agency to crack down on coronavirus fraud generally, and it's very much up and running. It's opened over 10,000 inquiries, some of them criminal. There have been dawn raids and arrests. The hunt is very much on. This morning, you're going to hear from Claire Treacy, who will tell us something about the background to furlough and common misconceptions. Then Kevin McKenna will speak about how issues are likely to arise in the real world. And finally, Wendi Bussin will talk about what to do if you think you may have a problem. Following these short presentations, there'll be time for Q&A, and please put your questions in the chat. We'll get to as many as we can. Only the panelists can see the questions. So let's get underway. I'm pleased to introduce Claire Treacy.
Morning, everybody. So I'm sure you're all now very familiar with the Furlough scheme because, as Robert said, it was introduced back in 2020, and at its peak, it was supporting 8.9 million jobs. The purpose of the scheme being to allow UK employers with employees on a PAYE scheme to designate some or all of their employees as furloughed workers if their work had been impacted by the pandemic. The scheme was initially due to come to an end in May 2020, but it's been extended numerous times so that it's now due to end on the 30th of September. Currently, the government are contributing 80% to furloughed workers' wages up to the cap of £2,500 a month. However, in July, the government contribution will start to taper off again, so that in July, the government will contribute 70%. Employers will be expected to therefore contribute the additional 10%. And then in August and September, the government contribution will decrease again to 60%, so that employers have to contribute the further 20%. When the scheme was first introduced, it obviously came at such a speed and on a really large scale in order to be able to respond to the pandemic. So this meant that at first there was very little guidance about what it was and how it should be used. However, as employers have obviously got to grips with it, and the government and HMRC, the scheme has evolved and the guidance started to come in thick and fast, which now means that we're actually on the sixth version of the Treasury directions which govern the rules of the scheme. So this lack of guidance, and then there being a lot of guidance, has obviously caused a lot of confusion at times for businesses about what is permitted by the scheme. So in particular, there's been a few misconceptions, one being about statutory directors. So what they were allowed to do whilst they were furloughed. I think a lot of businesses rather have thought that statutory directors can do their usual role, whereas actually the scheme rules are very clear and specific about what tasks or activities a statutory director is allowed to do whilst they are furloughed. It's also been thought, I think, by quite a lot of businesses that it's fine if employees carry out some work whilst furloughed, provided their employer did not ask them to do the work. Whereas again, the scheme rules are very clear that furloughed employees must not do any work which can be considered to be carrying out a service or generating revenue for their employer. And there is no exception to this if the employee carried out work off their own back. Those two terms, so the terms carrying out a service for the employer or generating revenue for the employer, they are very wide and they do encompass most work activities. However, many businesses have wrongly thought that if an employee is not literally making money for their employer by what they're doing, then that's fine, when unfortunately that's not the case. So if, for example, you had employees who were, say, working on a marketing campaign and perhaps that isn't even part of their usual job role, with the hope that, working on that campaign would mean that they would generate future business for the company once restrictions permitted, then it's more than likely that that's going to be considered work because it's indirectly generating revenue for the business and is going to likely be considered to be carrying out a service for the business. The HMRC, they are taking a really hard line with businesses and they will expect companies to have taken steps to ensure that their furloughed workers were not carrying out work, and also to have conducted some form of audit to ensure that furlough was not being claimed for employees that were actually working. Another one, just in terms of employees working on furlough, I think people or businesses have thought that responding to, say, one email or doing a very small work task whilst furloughed would not breach the rules. Prior to the introduction of flexible furlough in July 2020, employees could not undertake any work whilst on furlough. Therefore, depending on the context of the work email, which may have been quickly sent during furlough, that could amount to a breach of the scheme. And prior to flexible furlough, employees needed to be furloughed for at least 21 days at a time. Therefore, if there were no consecutive 21 days where employees did not carry out any work, then this could render all of the employees' furlough leave to be an overclaim. So this type of situation was obviously made easier by the introduction of flexible furlough in July, so that employees could work some of their usual hours and be furloughed for the rest of their hours. However, in order to be confident about when employees were and were not working during flexible furlough, employees must have a system in place that they can confidently rely on. And then just finally, I think another area where businesses may have slipped up with the furlough scheme is about volunteering whilst on furlough. So some businesses have thought that furloughed employees can volunteer for their employers rather. And at first, the government guidance wasn't entirely clear on this, but it is now very clear that volunteering whilst on furlough isn't allowed. And so employees can't volunteer for their own employers. And likewise, they can't volunteer for a company associated to their employer, for example, a subsidiary or a sister company. So that's everything from me in terms of the common misconceptions, and I'll pass over to Kevin, who's going to talk about how problems can arise if there has been a misuse of the furlough scheme.
Thank you, Claire. So I'm going to just talk to you about what I think are the four principal ways in which you might find yourself engaging with HMRC. So really a bit about what it might look like when it arrives at your door, how it comes to your door. And the first of those, I think, is through self-reporting. So arguably in one sense, maybe the easiest. So those organisations that spot early that there is an issue and choose to take those steps to make repayments. Or those organisations who find that in actual fact they didn't need the furlough payments in order to survive, and there are lots of high-profile examples of that. And so those organisations that self-report and say we're going to pay the money back. In the data that was shared just about a month ago, there was a total of 3,777 businesses who had repaid over £760 million in furlough grants from HMRC, to give you, I suppose, some sense of that. The second way in which I think there will be engagement is through nudge letters. So from the 20th of August last year, HMRC began issuing 3,000 what they called nudge letters each week, urging employers that they believed might have claimed too much under the scheme to review their claims. The letters and that narrative was couched in a way that HMRC said they understood that mistakes happen and they will not seek out innocent errors and small mistakes for compliance action. But of course, it as Wendi will come on to shortly, it will stand employers in greater favour if they don't respond to nudge letters, if they fall into that earlier category of self-reporting. As Robert mentioned, in the March budget, the government announced it would be allocating over £100 million toward a new HMRC task force dedicated to investigating fraudulent claims under its COVID support schemes. I think the next area where you're likely to see this engagement is through investigations. There is the fraud hotline and investment there. HMRC's fraud hotline received more than 91,000 calls during the first 9 months of the pandemic with concerns about likely furlough fraud. There's been an average of 10,000 calls per month from April to December, and that's up 1,000 calls per month on the previous year's average. HMRC will be seeking out irregularities in the data that they receive, and enquiries are likely to be sector driven. And if we're looking at those sectors of the economy which were most reliant upon furlough, then they're going to be in the areas of accommodation and food, wholesale and retail and repair of motor vehicles, administrative and support services, arts, education and recreation, and manufacturing. So some big areas covered there. The last area, though, where I think we're going to see these sorts of issues arising is not from any of those areas. It's from the people in the hearts of your organisations. It's from your employees. HMRC may look for patterns or irregularities or sectors, but the people who really know what's going on in your business are the employees. They know if they've been told to work, encouraged to work, whether you've turned a blind eye to them working, or whether you've banned or stopped them from working. And I suppose last year, people and many organisations were in survival mode, but that's changing as businesses and organisations now shape to move forward. So within the context of employees, how do these issues manifest themselves? Well, here I'd say that there are probably another 4 major ways in which I think you're likely to see the issues arise there. Firstly, I think it's, and this is on the evidence of what we see ourselves, from straight complaints within organisations about misuse of furlough. So most often where an employee is saying that they were asked to work throughout furlough, or where they know that others were asked to work, and this can amount to a protected disclosure. So I suppose a legal term, but a legal term that many of you might know falls within the broad context of whistleblowing claims. So where you are complaining about a breach of a legal obligation, a criminal act, and so on. And so how you deal with those sorts of complaints is important. Badly handled, it will give rise to whistleblowing complaints where you treat those complainants less favourably, or where they might even find themselves dismissed. And it's important not only because of the reputational issues, but there's also no upper limits on the compensation that's available to claimants that bring whistleblowing claims. The second area where I think that you will see these sorts of complaints and where furlough will be a factor will be in the general kind of issues that you might see that would form grievances. So that might be bullying and harassment claims, often couched in constructive dismissal claims. They can also include areas of discrimination. So it's the usual sorts of grievances that you might see, but where slotted in amongst the complaints that you've had excessive demands maybe by a manager and so on, is slotted in is that they were forced to work through furlough, or they were encouraged to work through furlough, or required to work through furlough. I think the third area will be in the area of redundancies and restructures. As businesses now look to the future and begin to reshape or downsize or restructure, then there will be engagement between the employer and the employee, usually in the form of a consultation process. Employees will face uncertainty, they'll face financial insecurity. And so as they look to leverage the financial payoff that they might be able to gain from their employer, then I think that you will find, and we have found, that consultations tend to be a forum in which employees will raise the issue of furlough and what you did, and the title of this, whether you got it right. I think the last area of the most common, in our experience, the most common areas where this will arise is in things like promised pay rises and bonuses. So we're seeing situations where some employees were told that if they helped out, then maybe would get rewarded when it was all over, or that they thought that that was the deal and that's maybe what they're entitled to. Lots of people will think maybe that they've worked harder than they've ever worked during lockdown. So don't be surprised when you come to pay and reward reviews if there are some employees who think that it's time to cash in their chips on having helped the business through furlough. So I mentioned these areas because these are all areas where ordinarily you will have processes and procedures in the business, whether that's through typically a grievance procedure or perhaps a whistleblowing procedure for how you deal with these things. But this added element of furlough irregularity does bring a different complexion to it. And so how you investigate and who investigates and how that all handled takes on a different complexity and a different complexion. And that's, I think, the area, if I can neatly hand over to Wendi, I think that you need to look at next.
Thanks, Kevin. Good morning, everybody. HMRC is giving employers some leeway to report excessive claims. It's not seeking to punish people for making mistakes, but it is set to tackle deliberate non-compliance with the furlough scheme. Now, if you think you've got a potential problem with misuse of the scheme, it is important to deal with it head on. Hoping that HMRC will not look is a dangerous strategy, especially given the manpower and funding of the new Taxpayer Protection Task Force. HMRC will look at the turnover of companies which have furloughed staff and queried whether that turnover is consistent with that furlough. It will examine PAYE records and look for employees who had temporary employment only during the furlough period, and look very carefully at new businesses. It has sophisticated tools available to it. Now, HMRC are likely to bring criminal charges in respect of blatant fraudulent activity. In those cases, those holding more serious roles in a business are likely to be at greater risk of any such offences, which could include charges of cheating the revenue, conspiracy to cheat the revenue where there's more than one person involved, and for the company, failure to prevent the facilitation of tax evasion. Depending on the amount involved, sophistication of the fraud, and length of time of the fraud continued for, a person convicted of such offences could face a significant amount of time in prison. Now, I don't mean to frighten you, but you need to be aware of the power of the revenue. However, as I said earlier, the revenue are not looking at every error as a deliberate attempt to cheat the revenue. There are civil recovery schemes available to them which enable repayment of erroneously claimed money which do not carry criminal sanctions, so long as the position is laid bare and truthful. In the civil recovery regime, not only will HMRC want full recovery of the erroneous claims, but they can seek penalties up to 100% of the tax concerned. These penalties can be reduced by various factors, including if it's prompted or unprompted, or if it's as a result of deliberate, careless, or innocent errors. The cause of the error feeds into whether or not HMRC decide to name and shame the business, which would obviously cause reputational damage to the business if they do that. HMRC will want to see the names, excuse me, the names of businesses in the press, as they will want to show it's protecting the taxpayer. So what do? Well, the first thing is to make sure your records are kept safe. Do not destroy any records, emails, etc. This will be needed for the next step, which is an internal investigation. It's important that an investigation takes place into whether errors were made, how that happened, and what amount needs to be repaid, if any. The reason for the error is of utmost importance in terms of how the issue is dealt with by the revenue. It is important that the integrity of the process is maintained, as it can help the business present itself as cooperative if HMRC engage with the business. Any internal investigation should be led by someone sufficiently distanced from the errors and any individuals who may have been involved. The preferable leader should be an independent external lawyer, which then enables the investigation to be covered so far as is possible with legal privilege. Whilst it is nigh on impossible to cover absolutely everything with privilege, it is better than having none at all. The material which does have privilege attached to it cannot be seen by HMRC if they become involved later down the line. Following that investigation, excuse me, it's one of those mornings, specialist legal advice will assist the business in making a decision as to what it should do next and whether the matter needs to be self-reported to HMRC. Whatever decisions are made, having undertaken a lawyer-led investigation and taken such advice will increase the likelihood of a favourable outcome. The best outcome is simply to be able to repay erroneous claims and no more heard about it. The next best thing is for HMRC to look kindly on the business in terms of any financial penalties and name and shame. But whatever happens, the fundamental point here is to tackle any potential issues head on and not simply hope it goes away. Now back to Robert, who's hosting our Q&A session.
Thank you, Wendi. We have a little bit of time for questions, following which I'll explain how you can follow up with us privately if you choose to do that. We have had a question in the chat box that is picked up on the wider aspect of furlough, which I'm happy to handle, about the fact that furloughed staff are sometimes finding it difficult to get finance, and some funders, and in particular, I think you're probably referring here to mortgage funders, won't lend unless you're clear of furlough for a clear 3-month period. I think we are, of course, seeing this. We're seeing this actually in our residential property area. And unfortunately, it's a case of commercial reality kicking in. Mortgage companies are nervous of furlough because they see it as potentially an indicator that the job is at risk if and when furlough ends, and they're therefore nervous about lending money on mortgage. The only suggestion I can make on that, and it is a matter for individual mortgage companies, it's not a matter which is covered by law, is to find a mortgage broker. who understands the lay of the land and can direct you to mortgage companies that have different underwriting requirements. I'm sorry, I can't be more helpful with that. It's not a matter that ordinarily would form the subject of legal challenge. I hope that's helpful. I don't know if any of you have anything to add to that. Okay.
No.
Now there is a question coming in about how furlough employee records will need to be presented, which I take to mean, what would the authorities expect to see, and what would an investigation, I suppose, if to your point, Wendi, the lawyer-led investigation, what records would we want to be seeing to check that things have been administered correctly?
Well, in terms of what I would do during an investigation is to examine the PAYE records. What records do you have of letters to employees to say you're going on furlough now, maybe letters in relation to flexi furlough as well, and do those letters set out what the employee can and can't do? I would expect to see whether emails have been used during the furlough period by the employee. Now, just using it itself does not mean somebody has worked. It's all about the context of the email. So employers have been emailing employees to keep in touch with them, let them know what's going on, and just look after their employees. That is not them working. But there may be emails where an employee has been asked to confirm whether or not they did actually do any work whilst they're on furlough. I would expect to see that in the records as well. I don't know if Claire's got anything else to add on that.
Yeah, there isn't a prescribed method that the government have said, you need to keep these particular records or anything. The one thing they have said though is that records about what you've claimed for furlough and the furlough agreements that you've got in place with employees, they need to be kept for 5 years. So that's the important time frame to have in mind. But other than that, yeah, I think you kind of covered it, Wendi, in terms of it's making sure that if anyone was to look into it, that you're able to show that your furloughed staff weren't doing work. So that obviously most of the time now that's going to be concentrated on looking at email traffic. I
think maybe just to add to that, I think it's also going to be business specific, and some of our learning and thinking on this has been informed by the way HMRC conducted investigations into national minimum wage irregularities, and that's where so we've got experience of that to be able to get a sense of how far, how deep, and in what areas they go. And that's going to be tailored to your business and the kinds of records that you're likely to have.
Thank you. An interesting one now that I know that we have come across in, and at this point it's worth pointing out, we've come across a range of client matters in this area, some initiated by the client, some initiated by HMRC. So we're building up a pattern and a picture of how HMRC are handling it and their approach. This is a question about workplace broadcasts and communication updates from the board. So the question really is, does that count as work? If you tune in to a regular business update, is that working?
I don't know if you want to answer that one, do you, or not? So it depends very much on the content of that broadcast and what was said at that meeting. Ideally, there would be minutes as to taken as to what happened during that meeting. If the minutes evidence that it was just business updates, then and the employees were just dialing in to listen to what was going on, then arguably that wouldn't be providing a service to the business and therefore not work. But if the minutes actually showed that they were being asked to do work or they were inputting, depending on what that input is, then potentially that would amount to work. So it very much depends on a case-by-case basis. We don't have specific guidance from the government about attending such meetings.
And every business has different procedures. You have small businesses where they're probably not going to keep minutes of updating their staff as to the latest furlough scheme or anything like that. But then you'll have big businesses where that flow of information is very well recorded.
Of course,
it comes down to the nature of that communication.
Of course, most businesses will have tried to preserve their contact with even furloughed employees for the purpose of their own well-being and stress management during a very difficult time. One must assume that is going to be within the range of permitted activity, no?
I think that's right.
I mean, to the person that asked the question, the problem I think we're going to face is that HMRC will test lots of different things. Some at the more blatant end of the spectrum, they will obviously push. There'll be other things which they can be expected to test. And unfortunately, the guidance was, I would say, far from clear during the material time. That gives plenty of scope for argument. And as I say, there'll be shades of grey that will have to be argued, and that's going to be something that I suspect we're going to be very involved in for clients over the next few years, actually. Thank you for that.
Can I just add, I think it's also a good illustration of that point about how things like national minimum wage investigations will inform this sort of thing. So borrowing some of those principles, if it's a workplace communication that's happening weekly, but you're required to dial in, then that's likely to be treated very differently. That's going to have more parallels with where HMRC have said in national minimum wage cases, well, if you've got to be in 15 minutes before your shift just for the team meeting, then that's going to be working time. And so that's why I say there are going to be some parallels, as Robert, as you say, there are going to be lots of arguments about these kinds of areas, I'm sure.
And every case is going to turn on its facts. I think that's already becoming extremely clear. I think that is it. We are 10:35. I hope you found that useful. Everybody who participates in this webinar will receive a communication after this with some contact details, just to say there may be questions you want to ask, issues you want to raise, issues you're facing that you want to discuss with the team. You can reach us through the website chat function. Those inquiries will all be forwarded to the specific furlough team, but you will get contact details in a follow-up email. I hope you found that useful. To all the presenters, thank you, and to all those of you who attended, thank you too, and have a good day.